So tell us about this new report. How did it come about, the background to it?
So this came about following the case of Keith Bandy, who died over 5 years ago now. Keith was staying with his mother, Avril. Avril was out working a night shift she's a nurse. She came home at 8 a.m. and found Keith slumped on the floor in the living room. She saw that he wasn't breathing. She dialed 999, and until the paramedics arrived, she carried out CPR herself on her son. The paramedics arrived, took over and worked on Keith for over half an hour, but unfortunately were unable to bring him back, and he was pronounced dead. When Avril's family were there, they were talking, while the paramedics were still there, they were talking about what had happened and couldn't understand what had happened, and wondered, in fact, if Keith had been attacked. And suddenly Avril remembered that she had CCTV installed above her front door and said, they could look at the CCTV and see what had happened and see if anybody had been in the house. And at that point, the paramedics that were still there looked up and said, well, actually, one of their colleagues had been there earlier. Keith had dialed 999 himself, and the paramedic had left after a very short time, stating that he was leaving because Keith was being uncooperative. And Avril and her family just couldn't accept that this was the case. They knew Keith very well. He'd had asthma all his life and was very careful about looking after his health. And if he'd asked for help from a paramedic, there's no way that he would have been uncooperative. So they complained to the ambulance service and asked them to investigate. The ambulance service were very slow about doing this, and it wasn't until the November of that year, Keith had died at the end of May, that they came back to the family and told them they'd investigated and had found that the paramedic had not been negligent and that Keith had been treated appropriately. Avril and her family couldn't accept that this was right, and Keith's father, Robert, started to investigate himself. He got in touch with the patient safety charity AVMA, who helped him, and Robert got in touch with the East Midlands Ambulance Service himself and asked them to let him have copies of call logs and records and documents that would help him to investigate. And with that information, they eventually persuaded the coroner to open an inquest, which was held in the October 3 years following Keith's death. And the inquest concluded that if the paramedic had acted appropriately and Keith had been taken to hospital, he would have survived.
I mean, that's such a shocking case, isn't it? You know, to lose your loved one and then to have to go through years of this heartache, rehashing it, fighting your case. It's terrible, isn't it?
It really is. And I think that when Avril and her family came to us at Access Legal, they had been through the inquest and still felt that the ambulance service weren't being transparent about what had happened, and moreover that they hadn't been held accountable for what happened. And they still didn't feel that they were left with any sense of having done justice for their son. So they came to us, and the process drags on even more. And in fact, if the ambulance service right back at the beginning had carried out an honest, transparent, accountable investigation and been upfront with the family about what had really happened, then they probably would never have come to see me to ask us to assist them, because they would have, I think, if the ambulance service had been honest with them, would have achieved some sense of justice at that stage.
I mean, seeking this kind of justice, this case is a prime example that there needs to be reform, doesn't there?
There does. Earlier on this year, a statutory duty of candour, as it's known, so basically an obligation of medical professionals to be open and honest when things go wrong, has come into force. There's been lots of research and evidence of this in the United States, where, because the health service there is run much more on a commercial basis, where hospitals are trying to reduce their litigation costs, they have looked at introducing this duty of candour so that there is a responsibility and obligation on the medical professionals to be open and honest when things have gone wrong and to try and put things right. And the evidence is that actually reduces the litigation costs. In America, it's very much been driven by a commercial imperative to get the cost down. I think in this country, it's been introduced, as well as with trying to get the cost down, trying to address this problem that Avril and her family have come up against, where they are trying to find out what has happened, trying to get some honesty and transparency, and they have been so far really unable to achieve that.
It's not only the case of of fighting for justice for their son's death. But there was also another issue arose when Mrs. Bandy tried to claim compensation as a secondary victim, because obviously very psychologically affected by this. But tell us about that.
So that's right. Avril and Keith's father, Robert, were both psychologically injured by what had happened. They'd both witnessed the paramedics carrying out CPR. Avril herself had carried out CPR, and the images of that will haunt them forever. Avril was employed as a nurse. She felt unable to carry out CPR on any other patient ever again, and was unable to go through the accreditation training required for her career as a nurse, and ultimately had to retire a couple of years earlier than she had intended. So she suffered financial losses as well as suffering injuries herself, which in the normal course of things she would expect to be able to claim compensation for. But because of some recent judicial decisions where the courts have narrowed the circumstances in which claims of that nature will succeed, she has been unable to claim compensation for her own injuries.
She's classed as not being a secondary victim because she wasn't actually there when he died.
Or there when the negligence occurred. That's right.
And it just seems all nitpicking at wording, doesn't it? And that's what frustrates a lot of people.
I think that's right. I think the courts are trying to balance the rights of those who've been injured, as well as protecting the resources of the NHS. They're trying not to open the floodgates to claimants, but that leaves people like Avril and Keith's father, Robert, in a very, very difficult position.
So this report shows as well, talking to people, that there is a need. People are out there. Are you hopeful that these kind of calls for reform, for change, are going to be heeded?
We hope they will be. I don't know that that's the direction of travel at the moment. I think the courts at the moment are trying to restrict the ways in which claimants can claim. Although I think the irony is that actually if we were to look at this the other way around and look at prevention rather than limiting those that could claim, the same financial savings outcome could be achieved in a wholly more satisfactory way for patients and their families.
If any of our listeners are affected by this kind of issue, if they feel that they have been a secondary victim, or if they have any way concerns about medical treatment, what should they do? Give up?
No, not at all. They can talk to a lawyer. They can contact us. Our website is access-legal.co.uk. They can look at the AVMA website, spelt AVMA, which has lots of information and signposting to other organisations that can assist. And
it may be difficult, but it's a long road ahead for many people. But do you think it's always justified?
In terms of bringing a claim? I think if people think that they have suffered injuries and financial losses as a consequence of somebody else's incompetence, then yes, they should.
Brilliant. All righty, Joe, that's all my questions. Thank you very much for that.
Thank you.